Your Honor, we're ready to proceed.
Your Honor, the state is here because the defendant has been charged with 6 counts of sexual battery, all life felonies, as well as kidnapping, which are all enumerated as dangerous crimes. Based on the report provided by Detective Rosano, the defendant used his position as a correctional officer at Lowell by showing his badge and indicating to the victim and her friend that he was law enforcement. It was later verified on the video. They were able to actually see the badge that he presented and put at the hot tub where the events occurred. The victim was quite clear and immediately reported when she was finally able to get away from the defendant, who had held her by the use of force. He sexually battered her on 6 separate occasions throughout the evening. One of those events occurred in the bathroom and caused rectal tearing on the victim, who was 17 years of age. He did make post-Miranda admissions, and additionally, early in his communication, he noted he thought he might be in trouble for having provided a minor alcohol. Therefore, he was aware that the individual was a minor. We are asking that he be held. This is a dangerous crime, and there are no conditions which could be provided for the safety of the community. He was also employed at the apartment complex where this occurred. I believe that was secondary employment to his work as a correctional officer.
Vince?
Yes, Your Honor. After having a brief conversation with my client, he was not aware at the time that the offense took place that this individual was 17 years of age, underage, which would explain why he was very concerned about having provided alcohol to someone who was underage. Though I recognize that there are post-Miranda statements that are made in the PC minimus, my client denies this being a non-consensual activity. And I would ask that the court deny the motion for pretrial detention. And also, Your Honor, though I understand there's also a surveillance video, I'm not in possession of that surveillance video to know what that could potentially depict, but we are relying on the single statement of a 17-year-old young person.
In addition to video, Your Honor, and in addition to witnesses that you reported to immediately.
All right, Mr. Lord, having reviewed the probable cause affidavit that's part of the court file, I do find that you are being held on what are defined as dangerous crimes under the Florida statute. I do find there's a substantial probability that you have committed those offenses based on the review of this document. And I do find that the factual circumstances of the offense do demonstrate a disregard for the safety of the community. And at this time, I'm not persuaded or convinced that there are any other conditions of release that would be reasonably sufficient to protect the community from further risk. So at this time, the pretrial detention motion from the state is granted. I do wish you good luck.
I'll be out to speak with you.